My name is Grant Rasmussen, Manager of Investigations with the Office of Fair Trading. This is a copy of the public information sessions we delivered in August and September 2014. Thank you for your time to watch this presentation about changes resulting from the repeal of the Property Agents and Motor Dealers Act 2000 and its replacement with the Occupations Act, the Motor Dealers and Chattel Auctioneers Act and the Debt Collectors Act. We appreciate you're all busy people and appreciate your investment of time to learn of these changes and how they impact on your business operations.
Forms under the Property Occupations Act have been simplified and streamlined. Under the new Act, we have replaced the existing appointment forms by providing one form that can be used by any agent for any appointment type. However, this may change depending on industry feedback from our consultation. We anticipate the new forms will be released a couple of weeks before the Act commences. We do not have a specific date, but expect it to be later this year. Please check the Office of Fair Trading's website and follow us on Facebook and Twitter for updates. Our details will be shown on the last slide of this presentation. Consultation with key stakeholders has been undertaken to test the usability of the forms, as all of the forms are new. This has provided us with feedback on what aspects of the forms could be changed to improve functionality. The appointment process should be simpler and clearer as we've reduced the number of forms, and the new forms should be easier to use. The appointment forms replace forms 20A, 21A, 22A, 24A, 25 and 26. The Form 23 reappointment will be deleted under the Property Occupations Act. The appointment forms contain the following information: a statement that explains the client should seek independent legal advice before signing the appointment, whether the appointment is a single appointment or a continuing appointment, the service to be performed by the agent, whether the appointment is for an open listing, sole agency or exclusive agency, the fees, charges and any commission payable for the service, when the fees, charges and any commission for the service become payable, the expenses including advertising and marketing expenses the agent is authorised to incur for the performance of each service, the source and the estimated amount or value of any rebate, discount, commission or benefit that the agent may receive for any expenses that agent may incur, and any condition, limitation or restriction on the performance of the service. The assignment provisions have also changed. An assignment applies if an appointed property agent or resident letting agent assigns the appointment to another property agent or resident letting agent. The new agent must give each client written notice of the change, that is, of the assignment, within 14 days after taking on the appointment. The written notice must state the following: the name and contact details for the new agent, that is, the assignee, the address of the new agent's registered office, that the appointment has been assigned without changing the terms of the original appointment, that the client may terminate the appointment by giving at least 30 days written notice to the assignee. The appointment can be terminated earlier if the client and the assignee both agree in writing. The appointment is taken to be an appointment by the client of the proposed assignee and to continue to have effect according to its terms. Therefore, no new appointment form is needed. In addition, it is recommended that a statement be included advising that the assignee does not have authority to vary the terms of the appointment without the client's agreement. The new agent cannot change the terms of the appointment without the client's approval. By including this information, you will clarify that the appointment terms remove any possible doubt or misunderstanding. You must have a valid appointment to retain the commissions you're entitled to as an agent. Under the Property Occupations Act, for sole or exclusive agency appointments, the statutory limit on the length of the appointment has been extended from 60 days to 90 days. You may sign an indefinite agreement for this type of sale, and when selling management rights, the 90-day statutory limit does not apply. You will no longer need to make a written statement to prospective clients about how your services are to be performed, but you do need to state which services are to be performed. For example, the letting, collection of rent, other property management services, or sales. You will no longer need to nominate an end date when you enter a continuing appointment. You may continue this arrangement indefinitely. When two or more agents collaborate on a sale, a separate appointment form for each agent will no longer be required. Under the Property Occupations Act, the rules of termination of an appointment have been simplified. Either party may terminate an open listing at any time by giving written notice to the other party. A sole or exclusive agency will require 30 days written notice of revocation unless both parties agree to an earlier termination date. However, for this to occur, the term of the sole or exclusive agency must be for a period of at least 60 days. All other appointment types may be terminated by giving 30 days written notice or less if mutually agreed by both parties on an earlier end date. A written notice can include an email, a fax, or a letter. Under the new Act, the cooling off period will not apply to private treaty contracts entered into within 2 days after an auction with a registered bidder. For example, if property is passed in at auction and a registered bidder makes an offer and the seller accepts, the contract is signed, but the cooling off period does not apply. However, if property is passed in at an auction and an unregistered bidder makes an offer and the seller accepts, the contract is signed, then the cooling off period does apply. The buyer no longer needs a signed lawyer's certificate to waive or shorten the cooling off period. To exercise statutory cooling off rights, the buyer will no longer need to date the termination notice and state the relevant section of legislation in their notice. However, they would need evidence of the date it was provided. The statutory cooling off period for an option contract has been clarified under the new Act. Now the statutory cooling off period only applies to an option contract when the buyer who offered the option contract ends up buying the property. For example, if you enter into an option contract and that person ends up buying the property, you do not need a new contract of sale. The option contract will suffice. The Form 30C warning statement will no longer exist. Instead, a statement must be written in the contract immediately above where the buyer signs. The specific statement must be written in full once, be in a conspicuous position, and sit directly above and on the same page where the buyer signs the contract. If the specific wording is not included, the buyer will not be able to terminate the contract. In that instance, the agent who gave the contract to the buyer commits an offence and may face a fine or prosecution. Beneficial interest provisions for options to purchase remain the same. However, the rules around beneficial interest for other than options have been simplified. As long as you act fairly and honestly, you may make beneficial interest sales without penalty. What is and isn't a beneficial interest is unchanged. A conjuncting agent falls within the meaning of associate and is subject to the beneficial provisions of the Act. You will need to disclose the beneficial interest by filling out the new form. The current Property Agents and Motor Dealers Act forms will not be acceptable. You will be allowed to charge a commission as long as you disclose it properly. However, chattel auctioneers cannot charge a commission on goods they have purchased to auction. The disclosure provisions to include house and land packages are now included. You must disclose to the buyer if you have any interest relating to the building contract or the land sale contract. For example, commissions received from building contracts may not have been required to be disclosed under the Property Agents and Motor Dealers Act. Under the Property Occupations Act, you must disclose to the buyer any person or company who receives a benefit or commission at any stage in the sale and the amount. Therefore, you must disclose to the buyer the full name of the person or company who receives or expects to receive a benefit that relates to the sale. Under the Property Occupations Act, you will no longer require the vacant land statement and lawyer's certificate. The vacant land statement is the statement to a buyer of non-residential vacant land that using the land for residential purposes is unlawful, and the lawyer's certificate of independence to the prospective buyer. The real estate commission cap has been deregulated. There will be no maximum limits on sales commissions, commissions for letting properties and collecting rents, and commissions on share farming or property exchange agreements. You need to clearly state in the appointment what your commissions will be. The appointment document provides you the authority to retain commissions. If the commissions are not clearly stated in the appointment, they cannot be retained. You will be able to charge a commission as long as you disclose the beneficial interest to the seller and then they subsequently agree to the sale. You will no longer need to disclose to the buyer about how much sale commission you will receive for the transaction. Under the Property Occupations Act, the laws for auction price guides have been clarified. Agents and auctioneers may not publish a price guide for properties at auction. However, they may disclose to an electronics listings provider and nobody else to establish a search criteria only, and that comes with responsibilities about ensuring no price or price range is disclosed on that electronic listings site. And they may undertake a comparative market analysis and offer this to potential bidders, but only with the seller's approval. Agents and auctioneers should be aware that bait advertising provisions under the Australian Consumer Law will still apply. Agents and auctioneers may disclose that a reserve price exists on a property, but they may not disclose the reserve price itself. The statement, "This property is on the market," will be allowed. You must have a Chattel Auctioneer's licence under the Motor Dealers and Chattel Auctioneers Act to hold a livestock auction. You no longer need client referees to pay out the proceeds of a livestock auction. Resident letting agents will be able to operate more than one building complex. A resident letting agent licence will allow you to manage any number of complexes with the appropriate body corporate approval. The Property Occupations Act will not require the resident letting agent to reside on site at the building complex. This is subject to appropriate body corporate approval. When applying for a licence, resident letting agent applicants will no longer need to give evidence that body corporate has approved them to work in the complex. Again, usual body corporate requirements will still apply. Thank you for watching this presentation. There are more presentations in the series available on YouTube. You can visit our website and keep in touch with us in a variety of ways.